He informed me that he is not happy with my representation. He does not feel that I have zealously advocated for him, and believes that it's my fault that Dr. Tovar is not able to testify, and has asked me not to continue working on this case anymore.
Mr. Cooper, you've heard the statements that your counsel has made on the record. Is that accurate?
Yes.
When did you give him this note?
Just a little while ago.
Mr. Pelright, your position or comment?
Unless Mr. Cooper's got counsel ready, willing, and able to step in and try this case in a few moments, I don't think there's any basis for doing it that way. It's similar in tone to the position I took on the other issue, and that is, while defendants certainly have serious constitutional rights, both due process and fairness and ability to put on defenses, they have to do that within the context of the rules of our criminal justice system. If defendants were allowed to fire attorneys whenever they felt unhappy at a ruling in the midst of a long, complex, difficult to schedule, and ultimately rescheduled trial, we would never get any cases tried. Defendants would be doing it willy-nilly. And the defendant's effort to do that in this case at this time, as desperate as it may be, should not be allowed by the court.
Anything else, Mr. Brabazon?
This isn't a topic Mr. Cooper and I have talked about, Judge. I can tell you from my dealings with Mr. Cooper, without getting into confidential information, he's been wanting this case to proceed. I think he was disappointed when it was adjourned in the past. So the fact that he is asking for this matter to get rid of me, I think it shows how important that is to him, because there is a strong part of him that wants this over with and wants closure. But I can tell from talking to him that something's changed as far as our communication and the way he feels about my representation. Just in the little 5-minute conversation we had in the back, I don't believe this is done with any intent to delay. There's been nothing in this case that ever suggested to me that Mr. Cooper ever wanted to delay this proceeding at all. All the delays that were in this case were because we were still preparing a defense and locating experts, and I know it's frustrating to Mr. Cooper that the case had taken so long, but he was okay knowing that it was going to be done in the right manner. But I can tell the court, like I said, I can tell from talking to him that this doesn't seem to be a knee-jerk reaction.
Remind me again, Mr. Brabazon, how many years have you been practicing law?
18.
Well, Mr. Cooper, I'm denying the request to allow Mr. Ed, or to accept your request that I allow you to fire Mr. Brabazon. I mean, clearly you're not in a position to defend yourself regarding this matter. You need legal representation regarding this matter. Mr. Brabazon has been on this case for 10 months. I asked him, I know he's been in legal practice, I thought, going on 20 years. That's why I asked him specifically. He's been an attorney licensed in the state for the past 18 years. I think the majority of his work, that entire period, has been criminal defense work. I can't comment on other defense attorneys you might have hired or not have hired, but you have one of the preeminent defense attorneys in northeastern Wisconsin representing you, sir. So a jury has been chosen. They're here, ready to go. This trial has been delayed, as we all know, a couple of times. At least I'm not assigning blame or responsibility for that. The court made rulings regarding those motions previously, and that record stands on its own. But this matter is ready to be tried, and we are proceeding. So that request by the defendant to allow Mr. Brabazon to withdraw in this matter is denied.